There was a huge victory this week for opponents of Don't Ask, Don't Tell, the 17-year-old military ban on openly gay service members. California federal judge Virginia Phillips issued a ruling striking down the law that bans gay men and lesbians from openly serving in the U.S. military. She said it violates due process and freedom of speech. The ruling will be appealed by the Justice Department. San Diego is closely connected to the military, and earlier this week we spoke to some San Diegans with military ties about their reaction to the ruling.
I know that it's a very controversial issue, but I have a brother who is gay, and I think that, you know, your sexual orientation should not ban you from serving the military.
If you want to serve, you should keep your preferences private. Simple as that.
I was gay in the military, and it made us feel like second-class citizens. And the reason those in position of authority think that it's going to boost morale or whatever it is, or reasons that they think that they can't serve honorably, they're wrong.
Joining me now to go over the details of the federal court ruling and the expected appeal by the Justice Department and the reaction of the Obama administration is legal analyst Dan Eaton. Welcome, Dan.
Thank you, Gloria.
All right, so this ruling that the judge issued, and it was brought by the Log Cabin Republicans. It's a national gay and lesbian grassroots organization. What did the judge say about the group's right to bring the lawsuit in the first place?
Right, that's the issue of standing. And what they essentially said was, look, Log Cabin had one or two members who were in the military who wanted to serve openly but who could not. And that was sufficient, said Judge Phillips, to confer standing on the Log Cabin Republicans to bring this lawsuit. That was a hotly contested issue. And if they hadn't gotten over that barrier, there would be no lawsuit.
So has the government brought forth evidence to defend the policy?
There was no evidence. The government just said, let's look at the law, don't ask, don't tell. This is a challenge on the face of the law. And they said, look, this is about constitutional analysis. Either it survives or it doesn't. So there was no factual evidence that the government brought forth. The Log Cabin Republicans, however, brought forth a great deal of factual evidence, and it was evidence that the judge considered in her rather long ruling on this particular issue.
All right, so at this point, the judge has issued a ruling barring the Department of Defense from enforcing the policy for anyone under its command. What actual effect does or will this have, or does it have now?
Well, it does have an effect right now, because what the judge has said is that, Gloria, this applies worldwide. They have to stop all discharges, all investigations concerning the Don't Ask, Don't Tell policy. But that is subject to an attempt by the Department of Justice to seek a stay or delay or suspension of the effect of that order. But as of now, anyway, the Department of Defense is under an obligation not to enforce any of that policy and not to go forward with any pending investigations.
What about those people who have already been discharged, who have left the service because of Don't Ask, Don't Tell? Will that affect them?
Not this particular order, because all it says is don't do it going forward. But perhaps if the Don't Ask, Don't Tell is stricken down, these people could reapply for reenlistment, which is what a lot of the people who were discharged pursuant to that policy who testified in this trial said that's exactly what they wanted to do. So ultimately the order could affect them, but as far as the stay and so forth, it doesn't have any immediate effect on them right now.
The Defense Secretary, Robert Gates, basically said, hey, you know, it's going to take an awful lot to put this into effect, to just stop it down. So is that what the stay request is based on?
That really is what it is, what the stay request is based on. Secretary Gates filed a 48-page declaration saying, look, there's a lot of administrative paperwork, a lot of policies and so forth that we have to go forward. And by the way, we may very well win on appeal. So you really should stay this effect rather than having us undo this very rapidly.
Well, that's the part I don't understand. Okay. The Obama administration campaigned against Don't Ask, Don't Tell, and yet the Justice Department is planning to appeal the judge's ruling. How can Obama be opposed to the idea of Don't Ask, Don't Tell, and yet direct his Justice Department to appeal it?
Gloria, it's a matter of process. What President Obama has said is, yes, I favor the repeal of Don't Ask, Don't Tell, but the people to do it, Congress. Congress enacted that law, and the people who should get rid of that policy are the members of Congress who enacted it in the first place. He says, a lone federal judge, I'm not comfortable with having that done. For one thing, it could undermine broad public acceptance of the ultimate repeal that President Obama is seeking.
So finally, Dan, what happens next? What's the next step?
The next step is that Judge Phillips is going to consider whether, in fact, the Department of Justice can show a likelihood of succeeding on the merits, whether, in fact, staying the order is going to harm other people. Meaning, for example, gay service members who are in the process of being discharged, or whether, in fact, a stay or not a stay is in the public interest. She'll go through that process and ultimately issue a ruling. But you can bet either way, there's going to be an appeal.
Thank you so much, Dan Eaton.
Okay, thank you, Gloria.